Hey y'all, welcome back to my channel. If you're new here and you feel like you got a little bit of that common sense that's not so common, go ahead and hit that subscribe button. And if you don't, common sense is a disease that is highly contagious. So if you just hit that like or that subscribe button, you will catch it, I promise. Now today on my channel, we're going to get into New York's Clean Slate Act. Found out there's multiple states with this and the details that go along with that. But before we get any deeper, remember I don't have any law training, I don't have any law degree, so don't come for me. But before we get deeper, first and foremost, my name is Key and this is What's the Key?
For me, break for me, break the body for me.
All right, y'all, plans for this video will be Baby Zoo and Z. Okay, see them here. They both were propagated from Zai. Y'all don't know who Zai is. Zai is from the earlier videos. He used to sit right here where Carisha's sitting now. Now, no one told me when I was birthing a baby ZZ plant, I was going to go through a 9-month birth cycle, okay? Not even joking. So the one in the pot, right? In the soil, I forgot about. I planted another succulent that passed away on top of it. And then as I'm clearing out that succulent, this is like 7 months later, the little thing popping up. I'm like, yo. Okay, so that's the story of that one. And then you have the other one. All right, I'm gonna show you her roots. Or that, I'm trying, okay? It's been about 4 months and this is what I got, okay? I told y'all, 9-month pregnancy dealing with baby ZZ. That's enough of that. Let's get into the video. As always, if you see me looking to the right, I'm looking at my notes, and any bell or munching you're hearing is my cat City doing kitty things. New York's Clean Slate Act. This was Senate Bill, Senate 7551A, and they've been trying to get this bill passed in New York since 2019. This bill passed in 2023. And this act is to amend the criminal procedure law, the executive law, the correction law, the judiciary, and the civil rights law in relation to automatic sealing of certain convictions. As you can imagine, there's a little bit of controversy going on about it. I'm not going to get too far into it. A lot of people that I saw are actually for it. But I just wanted to put this quote by Michael Tenousis. All right, picture here. Yeah, he needs to be seen. And here's the quote. The reason why this law is dangerous is because it makes it automatic for everyone, whether they want to change their lives or they don't, said Assembly member Michael. If a person has went 7 years without committing a fucking crime.
Be nice. I'm finding it.
I think the common sense will tell you they're probably living a pretty decent life and not trying to go back. If the police department hasn't caught them or had wind of them or anything in a 7-year period, then they're not doing their job right. Or the person could just be living a decent life.
Makes sense to me.
And they also do call this the common sense reform because it's just common sense. After a certain amount of time, if this person hasn't done anything and has been functioning in society, then yes, their record should be sealed. Remember, this is sealed, not expunged. And when I saw that, I was like, okay, so Clean Slate Act. I'm thinking of the whiteboard. You know how you used to erase it, but it had like a dirty board or dirty markers, and you could still see the little print listed because you didn't use the spray? That's what the Clean Slate Act is. And y'all gonna see what I mean when we get deeper into it. But that quote, I was just like, did you read it? Did you read it?
I need an answer ASAP.
And also a little bit of statistics. They said only about 0.2 are eligible and have had their records sealed.
What the fuck?
So it's not even a large amount of people that are getting their records sealed. The automatic sealing of convictions. Now, for traffic infractions, they can be sealed after 3 years. And when criminal conviction, they got a little bit more extra in order to get that record sealed. So if it's a misdemeanor conviction, as long as at least 3 years has passed since the defendant's released from incarceration or the imposition of the sentence, if there was no sentence of incarceration, then they can have their record sealed. And the only thing that would stop it is if they got convicted of a crime at that time. So if they got convicted right at the time they're trying to get their record sealed, the time starts all over for the offense. So it starts from the day of your last conviction. For a felony conviction, at least 8 years have passed from the date. See, I said 7. This is 8 years. 8 years from the date the defendant was last released from incarceration or from the imposition of sentence. If there was no sentence of incarceration, a defendant's detention for an alleged violation of parole or post-release supervision shall now interfere with the time calculation prescribed herein, unless they are incarcerated. So the start date for when the conviction can be sealed doesn't have to wait until after the parole. It can happen right after the release from jail. I like that because I feel like from once they're on parole and things like that, that is when they're starting to become a functional member in society. So it starts their time in society. So I 100% see why it's from the moment they are released from incarceration and out in the real world, because that will be time they're out in the real world, showing that they're not doing anything to be convicted of anything else again. If the defendant is subsequently convicted of a crime before a prior conviction is sealed, time starts at the date of that crime unless the criminal charge is not pending in New York. So what they're saying is we can't control what other states are doing. So if you're going to commit the crime, it better be in New York. They are not currently under the supervision of any probation or parole department for the conviction they want it sealed. So they have to be, although that time starts from the moment they are free from incarceration, they do have to fully complete the sentence with the probation and parole included to have that record sealed. The conviction is not for an offense defined as a sex offense or sexually violent offense. Good. Nothing else needs to be said. The conviction is not for a Class A felony offense, and then there is a few exceptions for that. The defendant does not have a subsequent felony charge pending in another jurisdiction that is not a felony charge related to reproductive or gender-affirming care or the possession of cannabis, which would not constitute as a felony in the state of New York. So if the charge is anything other than something to do with gender-affirming care or possession with cannabis, because they're like, hey, we support that over here, so we don't care about it over there, then yeah. That's crazy that them can be, it's right, you're right. I'm thinking about current, but yes, cannabis, gender, that stuff is felonies in other states. Crazy. This paragraph should all apply if and when appropriate federal authorities grant access to records necessary to query to effectuate the purposes of this subparagraph in an automatic manner. So basically what they're saying is they shouldn't have to. It's a system in place. 7 years went by, ding, the record pops up or whatever automated AI they're going to start using for this. And then look at it, see they don't have anything pending, boom, seal the record. If the conviction remains ineligible for sealing, the Office of Court Administration subsequently check for eligibility no less than quarterly, or the receipt of a form in accordance with the conviction shall be released and all other conditions are met. So if it was not eligible then and it's past the time period where they can be eligible, I wonder why they wouldn't be eligible if it's past the time period of them being eligible. Or are they just looking at a bunch of records? Oh, New York don't have, that's too many people. Y'all need to get an automated system that has like a record, or somebody hasn't been dinged in the system for a crime or something for years, or the crime pops up and things like that. Don't make these people have to go through these files. Y'all need some type of automatic in place, okay? But they want them to check it quarterly if they weren't eligible, I guess, 3 months ago. In accordance with all other applicable laws, rules, and regulations regarding the scope, access, use, disclosure, confidentiality, and retention of criminal history information, records of conviction still pursuant to this section, including photographs, photographic plates or proofs, palm prints, fingerprints, retina scales, shall not be accessed by or made available to any person or public-private agency, except, and we're going to get into the list of people that can access it: the defendant and their counsel, any court, defense counsel, or prosecutor for the purpose of pending criminal charges or proceedings brought in a criminal court. Okay, and this is when I started to say, yeah, you erase the board, but you can still see the lining. So is it really a clean slate act?
No.
If the next time a crime happens, even if it's 10 years later, they can start pulling those records again? Qualified agencies and interstate and international authorities, when acting within the scope of their law enforcement duties, the court, prosecutor, and defense counsel if the defendant becomes a witness in a criminal proceeding. Don't be a witness. Your record's going to be unsealed. When an individual is a defendant in a criminal proceeding or proceedings brought in a criminal court, and the sealed records of conviction of a third party are integral to the defense. So what they're saying is that, hey, their record, and somebody can just start snitching on you in court, and then your records can be unsealed.
The woman was too stunned to speak.
Woo! That's messed up. Use of sealed records of conviction shall be requested upon ex parte motion in court, any court where the action is pending. The applicant must demonstrate to the satisfaction of the court that records will be used for the purpose of what I just listed, and same for individuals or entities that are required by a local law, state law, or federal law or regulation to request and receive a fingerprint-based check of criminal history information. Nothing herein shall prohibit the Commissioner of Education or the Office of School Personnel Review and Accountability from receiving or using conviction sealed for individuals or entities that are authorized by local law, state law, or federal law or regulation to request and receive a fingerprint-based check of criminal history in relation to the individual's fitness to have responsibility for the safety and well-being of children, adolescents, elderly.
Oh. Okay.
Individuals with disabilities or otherwise vulnerable populations. The Division of Criminal Justice Services shall maintain up-to-date records, list of citations of the local, state, and federal states of federal regulations I just described. Yo, and that's what I'm saying. Clean slate. Are we really giving them a second chance?
I need an answer ASAP.
There are still things they cannot do. So it's a partial clean slate. Any prospective employer of a police officer or peace officer, which I do understand, and I will say that I do understand why they should be able to see all history. But I feel like the history that matters should only be the what is visible. So what I mean by that is if it's assault that they're looking for and the record was never assault, that was the charge, then it shouldn't be able to pop up. It shouldn't be able to, like, y'all get what I'm saying. But any prospective employer of a police officer or peace officer in relation to an application for employment as a police officer or peace officer, provided, however, that every person who is an applicant shall be furnished with a copy of all records obtained under what I just said. So if you are going to get into the records and they become unsealed and you get to be, and they are visible to you, you have to give that person a copy of the records that you are seeing. And you have to give them the opportunity to provide an explanation. My thing is, are they going to care? Are they going to care? Are they going to believe them? But I feel like y'all should, because if y'all had to go and get the record unsealed, that means that person has been a decent functioning member of society. In some cases, at least 3 years, and in other cases, at least 8 years. So it should. But, you know, any federal, state, or local officer or agency responsibility for the issuance of licenses to possess a firearm, rifle, or shotgun, or with responsibility for conducting background checks before transfer of sale of a firearm or explosive when the officer or agency is acting pursuant to such responsibility. Again, with the clean slate. Most firearm charges, I don't think, and correct me if I'm wrong in the comments, I don't think any firearm charges are misdemeanors, right? If you're not supposed to have it, wouldn't it automatically be a felony? So it's been 8 years. They can't possess a firearm again? My thing is, do y'all think some people are just so stuck in it? Like, America watch too much TV. Do you think some people are just really that stuck in it that they just waiting that 8 years for their slate to be clean just to do something again and then have it like a reset for them? If you ain't forgot about it in 8 years, then shit, do it. Do it! Also, for the purposes of a civilian investigation or evaluation of a civilian complaint or civil action concerning law enforcement or prosecution actions upon ex parte motion in any superior court, any district court, city court, or the criminal court of the city of New York, provided that such court sealed the record, the applicant must demonstrate to the satisfaction of the court that the records will be used for the purposes of what I'm about to list. Information provided to an individual entity pursuant to what we just listed, so those firearms, the people working with elderly, children, etc., provided all identity information is removed. When an individual seeks to avail themselves of a public program or benefit, including but not limited to an immigration benefit for which sealed records of conviction of a third party are otherwise authorized by law or legal process. Y'all see how they had to put immigrants in there? They said, for example, immigration. Like, chase. For which the sealed records of conviction of a third party are otherwise authorized by law or legal process to be disclosed in furtherance of their application for such program or benefit. In such instances, the individual or their attorney shall request the use of sealed records pursuant to a form as prescribed by the chief administrator of the courts. So if you, in that 8 years, well, I guess if you're already using benefits in that 8 years and your record becomes sealed and you reapply and things like that, I mean, they're just seeing the same stuff. It's not like they would be fully functional and then all of a sudden go on benefits. They would already be on benefits. So I think that's one thing. In such instances, use of sealed records shall be requested upon ex parte motion in any superior court, district court, city court, town, village, house, mama's house of the city of New York, provided that such court is where the action is pending. The applicant must demonstrate to the satisfaction of the court that the records will be used for the purpose of this. Transportation network companies that are required to, or authority state law to request criminal history pursuant to the traffic law, which, you know, you kind of, if you're going to have somebody crossing borders, you probably do need to know a little bit about their criminal history. Now, that doesn't go to stop to say what I've been saying, this is not a clean slate. I'm just saying, yes, there are things in place that you should see their full criminal history, but should it stop them from getting the job is what I'm saying is no. Although you have access to it, please take into consideration that they have been a functional member of society for at least 3 to 8 years. The State Education Department, for the purpose of investigating professional misconduct, is defined in the education law consideration of restoration of a professional license or determinations for issuing a license to practice a profession or issuing certificates and privileges for which a prior licensure is required. For the professionals under this articles, and they listed a whole bunch, as such professions are defined in education law, provided that the State Education Department certifies the Division of Criminal Justice Services that is investigating an individual's license to practice a profession. The Board of Regents may consider any prior conviction that formed the basis of a determination in a disciplinary proceeding in the rules and regulations promulgated? What the fuck is promulgated? Oh, to promote or make widely known. Okay. Then we gonna say promote. Hell, saying that word before gonna mess me up. I can't keep trying to say that. Rules and regulations promote in an application for reconsideration, even if such conviction later becomes sealed, okay? The Office of Mental Health and the Office for People with Developmental Disabilities, where such agencies are statutorily authorized to receive such information, provided further that such information may also be available for case review as well to providers licensed, funded, designated, certified, or otherwise authorized by the Office of Mental Health or the Office for People with Developmental Disabilities, where such information is included in the clinical record of any person under the care of receiving services from such provider or program. Yes, if you've got a mental health problem, we need to see your past criminal history, whether sealed or not. I agree with that one as well. You'll be surprised how some people in their modern day behavior, could seem cool now for 5, 10, even 15 years. It's coming from my counselor brain, y'all. And then one time they just snap. Hey y'all, editing Key here. I had to jump in because video Key was sounding a little bit like a hypocrite. Now, what I mean by snap is not necessarily mean they go out and commit a crime, but they just stop doing their everyday normal activities. Maybe they're not enjoying going out with their friends. They're not taking care of their children. The work performance has went down, just something. And then it could have related to that crime that they committed 15 years ago. There could be guilt being held on, or just feeling low about it, or just kind of thinking about it because they know it was just so wrong. That's just what I mean by snap. The weight of what they did, it could be holding on to them, and it affects their mental health. Not necessarily mean go commit a crime. And yes, it had to do with something that happened maybe 10 or 15 years ago. So as a mental health professional, I might be biased with saying we need the record, but we do need those records. Might not judge you for them externally, but we do need the records. Where the sealing required by this section has not taken place, including where supporting court records cannot be located or have been destroyed, and a defendant or their attorney submits a valid form of such fact to the Office of Court Administration, such conviction shall be sealed within 30 days of the receipt of such form. So they're saying even if you don't got the paper copies, if a person comes in with the person that's defending them and they give y'all the info to say, hey, we need these sealed, this would have qualified to be sealed. Although the court may not have records, they may have been destroyed and you can't find them. If they provide you the information, you got 30 days to seal them damn records. So don't be out here trying to fake loosh on black men. That's basically what that little protection was. Don't be out here trying to fake lose stuff on black men.
I said what I said.
Now, the Department of Corrections and Community Supervision, in coordination with the Division of Criminal Justice Services, shall provide the Office of Court Administration with the data necessary to determine appropriate records to be sealed pursuant to this section. including but not limited to the date or dates of the release from the state of incarceration of the individual who has the sentence, and the dates of the initial parole or post-release supervision, and corresponding date or dates of discharge as applicable. All those dates are necessary because, one, you need to know when their process starts for their 3 years or 7 years, and then you also need to know that they are done with their parole, probation, etc. to get that record unsealed. So yes, they need all those dates. The Chief Administrative Office of each local correctional facility shall provide the Office of Court Administration with the data necessary to determine appropriate records to be sealed, including but not limited to the date or dates of what we just described. Upon the sealing of conviction pursuant to this section, the Office of Court Administration shall immediately notify the Division of Criminal Justice Services, the Court of Conviction, county clerks, and the heads of all appropriate police and sheriff departments, prosecutors' offices, and law enforcement agencies that the conviction is sealed. Upon receipt of such notification, records of or relating to such conviction shall be immediately sealed as follows. Every fingerprint or photograph, any plates, any proof, palm prints, okay, retina scans, taken or made of the defendant in regard to the sealed conviction, all duplicates, reproductions, and copies thereof, except a digital fingerprint that is on file with the Division of Criminal Justice Services for a conviction that has not been sealed pursuant to this section, shall be marked as sealed by any entity notified under this subdivision by having any such photographic plate, all that stuff I just named. They said whoever has it needs to seal it. And all you have to do is put at the face of the record, it was sealed, it's blah, and did not have, everybody can have access to it. Every official record in paper and duplicates and copies thereof, including but not limited to judgments and orders, published court decisions, opinions, records, briefs on appeal relating to the sealed conviction or file with entity notified under this subdivision shall be marked as sealed by conspicuously indicating on the face of the record at the beginning of the digitized file that the record is sealed. Entities subject to the requirements of this subdivision shall not use or access any sealed information unless otherwise authorized. Nothing in this section shall be construed to interfere with the applicable laws, rules, and regulations requiring the Division of Criminal Justice Services to administer and maintain criminal history records. So they're not saying don't maintain your records, all of a sudden delete whatever, bye, but they should be sealed and nobody should be having access to them like that for minute things. Nothing in this section requires the sealing or destruction of DNA information maintained in the New York State DNA database of an individual whose conviction is sealed under this section. So it could be a moment where they find the DNA at the scene or DNA for anything and then see the record is sealed. That's what I mean, clean slate, but you see that little dirt. You still see the little dirt in the outline from the old words and the words overlapping, okay? Nothing in this section requires the sealing or destruction of records maintained by the Department of Motor Vehicle Services, and nothing in this section shall be construed to contravene the Vehicle and Traffic Law, the Federal Driver's Privacy Protection Act of the Real ID Act, the Intelligence Reform and Terrorism Prevention Act of 1986, and the Commercial Motor Vehicle Safety Act, the Motor Carrier Safety Improvement Act, and or regulations promoted to this chapter or act. So basically anything when it comes to traffic and driving and terrorism and yes. Division of Criminal Justice Services is authorized to disclose a conviction that is sealed to entities that are required by federal law or by rules and regulations promoted by a self-regulatory organization created under federal law to consider sealed convictions. Such entities must certify to the division that they are required by federal law or rules and regulations to promote whatever and everything in order to get the sealed records for employment, licenses, etc. All that stuff that we listed before that you can get into their sealed records for. All right. To the extent permitted by federal law, a record seal may not be considered a conviction that would prohibit the employment, licenses, or clearance of the defendant. So they're saying, because you see it, it's sealed. They haven't done anything. You cannot use it against them. Will it still be done? I highly think so. But they're putting in here, can't use it against them. Nothing in this section shall prohibit entities required by federal law to consider sealed convictions or by rules and regulations promoted by a self-regulatory organization that has been created under federal law from making an inquiry about or considering an applicant's criminal history for purposes of employment, licensee, or clearance from inquiry to convictions. So they're basically saying if you have to see it, then yeah. And I think for the If it's your own little thing and you have to see the records, then you get to see the records. To the extent permitted by federal law, a record seal may be considered a conviction that would prohibit the employment, licensing, or clearance of the defendant. Okay? So if you see it, you can't look at it as if it's something wrong, although you have access to it and see that they did do something wrong. It sounds like something that sounds good to help the person, but in reality, is it really going to help the person? Even though you're saying don't see it as a conviction, they still can see it. And they can make up any other excuse for why they don't want them. Nothing in this section shall prohibit entities required by federal law to consider sealed convictions or by rules and regulations promoted by a self-regulatory organization that has been created under federal law for making an inquiry about or considering applicants' criminal history for purposes of employment, licensing, or clearance from inquiring to conviction seal. So they said, yeah, for those jobs and stuff that need it, you can't put anything in place to stop it. In any civil action, an official record of a conviction that has been sealed pursuant to this section may not be introduced as evidence of negligence against a person or entity that provided employment, contract labor or services, volunteer work, licensing, tenancy, a home purchase, a mortgage, an education, a loan, or insurance if such record was sealed and was not provided to the person or entity by or on behalf of the governmental entity in accordance with this section in response to such a person's or entity's authorized and timely request for conviction history information. So they're saying the little civil disputes when you get mad, you mad at so-and-so, you mad at your neighbor, and you know them your whole life. You can't be bringing up what little Tommy did when they were 17, 18, 19, and y'all in y'all 30s, 40s, etc. to use in a civil dispute. To make it seem like, oh, they're a bad person. The government saying, no, the record's sealed, doesn't count against them. Can't use it.
Makes sense to me.
A person or entity described in this subdivision acting reasonably and in good faith may not have a duty to investigate the fact of a prior conviction that has been sealed pursuant to this section. So they're saying you don't even have to, investigate the prior conviction if you don't want to. They're saying you don't have to. Even if it is, required, you don't have to. If you see that it's sealed, you can take that as that's how I'm interpreting that line. If you see that it's sealed, you can take it as it is and be like, okay, we're good. No record.
Oh, yeah.
No defendant shall be required or permitted to waive eligibility for sealing pursuant to this section as part of a plea of guilty, sentence, or any agreement related to a conviction for a violation of the laws in this state. Any such waiver is void and unenforceable. So they said, don't be trying to strike deals with people and saying, yeah, we'll lighten this, but you can't clean your slate. New York said no. Y'all won't be. That's another way they would try to get black men getting out of the Clean Slate Act. That right there. Good job, New York, for catching that and putting it in. Sealing is without prejudice to a defendant or their attorney seeking further relief. Nothing in this section is intended or shall be interpreted to diminish or abrogate any rights or remedies otherwise available to the defendant. So they're saying don't use this Clean Slate Act to say, well, since your record's cleared, you can't have... No. They still get every other right. This is just an additional one. God, New York must got some grimy-ass lawyers and judges.
That's my opinion!
The Office of Court Administration shall make diligent efforts to properly seal all conviction records eligible for sealing where such convictions were entered on or before the effective date, and in any event shall ensure sealing of such convictions is complete no later than 3 years after such effective date.
What the fuck?
The woman was too stunned to speak.
3 years?
Fire everybody.
I'll see. New York, y'all gonna have to get the word out there so people go start submitting their thing. They gonna get even 3 years. I get it. It's gonna be a lot of records. And they'll probably get to a point where it doesn't even take a long time because they'll get caught up eventually. But dang, 3 years, you got an expedited process in there? Sheesh. A conviction which is sealed is included within the definition of a conviction for the purpose of any criminal proceeding in which the fact of a prior conviction would enhance a penalty or is an element of the offense charge. Here's another one where I said the white dry erase board's looking real dirty. Because if they do something anytime later, you can unseal that record. This is what I'm saying. I get y'all trying to say clean slate, but this ain't a clean slate. This ain't a clean slate. It's not a little foggy slate. Nothing in this section shall be construed to permit sealing of a conviction before the expiration or termination of a sentence of incarceration, parole, probation, or post-release supervision for such conviction. I didn't get that in there, but you gotta put it in there. Somebody might find something. No, I'm not a lawyer. Nothing in this section shall be construed to affect or invalidate any active order of protection issued in relation to a conviction sealed under this section. Nothing in this section shall be construed to require or authorize the discharge of the requirement to pay any restitution, reparations, fines, surcharges, or fees imposed for a conviction sealed under this, or in the sealing of a criminal or civil proceeding for the collection of any amount due unless such proceeding is otherwise eligible for sealing under this. So they saying even in your record, you still got to pay off whatever you paying off. So if you still paying off some 3 years later, etc., you still got to keep paying it off. Sealing your record doesn't mean you automatically stop. Now, this section is what they added into the executive law. Nothing in this section shall authorize a division to provide criminal history information that is sealed to an entity other than those authorized by such, the ones that are listed, except as otherwise required by law. Every entity that receives criminal history information for civil purposes shall provide or ensure the provision of such a copy of criminal history is provided to that individual. And they can seek to have any corrections made and etc. The judiciary law has been edited to add this. They have to promote a standardized form and process for individuals to notify the court of an administration of conviction subject to sealing, but for ones that have not been sealed or, been taken into action to start being sealed yet. And also a form and process for individuals authorized to request sealed records in general. So you can create hey, here's a button just in case you ain't see mine. But my name should be doing, then they look up your name, or they say, hey, you put in the form and say, hey, I need this to be sealed, which would be in probably a lot of those cases. I'm assuming the bail is for your records are on file. The other one is for if they got it lost or destroyed or anything like that. Another part of the executive law that's going to be amended and added in is it shall be unlawful discriminatory practice unless specifically required or permitted by statute for any person, agency, bureau, corporation, or association, including the state and any political subdivision thereof, to make any inquiry about whether in any form of application or otherwise, or to act upon adversely to an individual involved in any arrest or criminal accusation of such individual not then pending against that individual, which was followed by a termination of that criminal action or proceeding in favor of such individual, or by an order enjoining the criminal action and contemplation of dismissal, or by a youthful offender adjudication, or by a conviction for a violation sealed, or by a conviction which is sealed except where such conviction record is access connection with the license, housing, employment, including volunteer positions, or providing of credit or insurance to such individuals. Provided further that no person shall be required to divulge information pertaining to any arrest or criminal accusations of such individual not then pending against that individual, which was followed by a termination of that criminal action or proceeding in favor of such individual, or by an order enjoining the criminal action in a conviction for a violation sealed by, or by a conviction which is sealed except where such conviction record is assessed. An individual required or requested to provide information in violation of this subdivision may respond as if the arrest, criminal accusation, or disposition of such arrest or criminal accusation did not occur. So what they're saying is they're making it against the law for you to be inquiring about somebody's record and things like that when you're not one of those people. They don't want you to act in any negative way towards them. And they can, if you bring it up, they can say it's not a thing. They don't blah, blah, blah. They can deny it. So I feel like this is the part of the law that gives somebody a right to sue if they feel like, hey, my record was sealed, but they still use it against me and they're not one of the people who could and do this and etc. and that. And I think that opens up people to be able to sue. And then they say no person is required to divulge the information. I wonder if that just means on an application, they're allowed to put no criminal history or no, etc. That's what I'm getting out of that section. Let me know if y'all see something else. That section also does not apply to any firearms. And the other places we missing children, elderly, etc. For purposes of this subdivision, any action which has been adjourned in the contemplation of dismissal shall not be considered a pending action unless the order to adjourn, and contemplation of dismissal is revoked and the case is restored to the calendar for further prosecutions. Now, this next section has to do with the access to information of incarcerated individuals via the internet. Notwithstanding any provision of law to the contrary, any information relating to the conviction of a person that is posted on a website maintained by or the other department under Article 6 of the Public officer's law may be posted on such websites for a period not to exceed 3 years after expiration of such person's sentence, imprisonment, and at the conclusion of any period of parole or post-release supervision. So I wonder if that would include, 'cause I remember back in my hometown,
Back in my day.
they did this thing where they would post everybody who got arrested on a Facebook page. I wonder if it would even count towards that. Like, hey, from their arrest, if their picture's on there, you got to delete their arrest picture off, okay? You got to delete any picture you had of them of when they were in the DOJ. Because you can go look for somebody who has been in the Department of, or DOC, the Department of Corrections, and see their picture for years. Every time they switch to a new facility, they got a new picture. So they're saying get all that off the internet after 3 years of when they complete their lives. Which, yeah, it's maybe a little long, but 3 years, you can go with 3 years because that makes sense. That's where the traffic law and misdemeanor starts. So for 3 years, it can be on there because they do something crazy. But them need to get up off the websites too. Just nobody should be able to Google their name and start finding pictures of them on the websites. Because a lot of people can do it, you know, the way we become tech savvy nowadays. A lot of people just start Googling, do their own research, do a Reddit thread, do anything, and just find an archive with a person's name that can give you a little idea of what they were in there for, even though that record was sealed. The record's sealed, but that archive thing says, like, released, they were in there, assault, robbery, theft, or something like that. Just a little few lines, no details, but it still gave you what that person did. So I get that internet part. The Civil Rights Law is amended by adding a new section to read as follows. Any person who had a conviction sealed may bring a cause of action for damages against a party who, without consent of such person, discloses such sealed convictions where the respondent owed such person a duty of care, the respondent knowingly and willfully breached such duty, the disclosure caused injury to such person, and the respondent's breach of the duty was a substantial factor in the events that caused the injury suffered by such purpose. I said that last section gave you the right to sue. This also is another reason to give you to sue. You can give them a suit for them because you feel like they discriminated against you with your records. You discriminate, and then you can sue against somebody else that disclosed your records, your sealed records, and it caused injury. I feel like that's fair enough. For purposes of this section, the party owes a duty of care. And you know why I feel like it's enough? Because I know how some people probably be like, I don't know if they did so-and-so or blah, blah, blah. I might tell them. I get it. But like I said, if they functioned 8 years in society, 3 years in society, didn't do anything, is trying to be a decent person, leave them alone. They serve their time. Some of y'all, I said this once, y'all only believe in second chances because you want it to apply to yourself. This world does not believe in second chances when it comes to applying it to somebody else. You gotta at least give them another chance. For purposes of this section, a party owes a duty of care to a person who had a conviction of the criminal procedure law when the party is under an obligation or when the party obtains access to records of such conviction for a specified purpose. Caregiver shall mean a person employed to provide care of a child or children or elderly or vulnerable adult in the home of such a child, children, or elderly or vulnerable adult. This act shall take effect 1 year after it became a law, effective immediately. The addition, amendment, or any repeal of any rule regulation necessary for the implementation of this act is an effective date are authorized to be made and completed on or such before date. So anything they need to fix and move around so that the Clean Slate Act can act into effect, meaning those procedures y'all have for those sealed records and stuff like that, boom, you have to do it. So that is the New York's Clean Slate Act. And we're going to get coming into some of these myths and facts. Because this common sense folks don't tell you that people won't just read on their own and go look up things on their own. Some of these myths and facts should, okay? Matter of fact, we don't even need to go over the facts because we read the bill. We know. Myth. So some people believe our children will be in danger because schools and daycares won't know if they're hiring people with criminal records. What does the act just say? But when it comes to children, vulnerable personnel, etc., they pull your record. Who is telling y'all this? Republicans? Guarantee it's the Republicans, okay? They get their information off Wikipedia. Another myth is law enforcement agencies will unknowingly start hiring people with criminal records. Who else was listed in there? Police officers and peace officers. Stop taking everything y'all hear and running with it and running y'all mouths with it and telling false information to people. And go look it up yourself. Even when people tell me stuff, a lot of times I nod my head, Sometimes even as people are still talking to me on the phone and they're telling me something that I'm just not sure of just because I have never done I'm just ignorant to it. I don't have any knowledge. I never did any research. I might be Googling it at the same time. And a lot of the time, majority of times with my friends are the type of people who just start speaking about some shit they don't know. I'm reading exactly what they're saying out loud. But if they had just read the bill, and that was in the top part, that didn't even take that much scrolling to do. I don't think it did. The Clean Slate Act will completely erase criminal records. I already told y'all, the Clean Slate Act was that dry erase board that's still dirty. No, it's not. A lot of people still got access to that records. These myths are crazy because it's all you got to do is read the bill. But these are the myths. This will seal records of dangerous people like murderers. Some type of crimes like murders are never eligible for that. Okay? Okay? Other than that, the other people, if it was that dangerous, they either one, still in jail, and two, they will definitely be the 8 year that they would have to wait before their records are sealed. And like I said, if they became a decent person in 8 years, leave them alone. They ain't did shit in 8 years. I know some people who was, we in our 30s, they cool now, but younger, they was crashing out. Younger than would have went crazy, but they are nice and composed now, and I couldn't even imagine they having to stop and mess up their whole lives based off some stuff they did back then, and they ain't did shit in 10 to 12 years. But if they'd have read the act, they'd have known these dangerous or the more violent crimes they're thinking of probably 8 years. That person has to be for 8 years. You still gonna be scared of that person after 8 years? You didn't probably walk them past that person multiple times in that 8 years, especially if they're in their neighborhood. Victims will lose justice once records are sealed. I don't understand. It doesn't lessen any penalties. You can't even get your records sealed until you're done with the full penalty you received. So a victim's justice in your mind is not only giving them that double punishment y'all want to do, giving them the jail time, the parole time, losing all that stuff. And then once they're even done serving all that time, you still don't want them to be functioning just because they did something in life. And I tell people, you are lucky that you just never got caught. Because there's not one person in this world that hasn't done something illegal that wouldn't have gave them a charge. And even as minute as you think it is, it could have been a felony charge.
Blow the dust off of your common sense and utilize it, please.
They said that Clean Slate allows any record to be sealed at any time. Again, when did they ever say that?
Give me an answer.
The restrictions are at the beginning, 3 years and 8 years. Low. People just be talking like, I think I read somewhere, now these coming from other countries, but they said that average American education is a 5th grader, and I believe it. I believe it. Because if you just read the damn thing, none of these would be a thing. Asking about someone's criminal record would be illegal. No. It doesn't change them. You can ask. Sealing criminal records is dangerous. Why? How? That don't even, bro, that sound like somebody, I'm not doing that one.
I don't want to hear that. Because first of all, how do you know? How do you know that that's true? How do you know that
Clean Slate was rushed through legislation with no care or thought. The same bill that couldn't get pushed since 2019?
It's just bullshit.
Bro, this sound like a bunch of Republican people. Sealing records encourages people to commit more crimes. Like I said, we're going to wait 3 years or 8 years and be like, fuck it. Finna fuck up my record again. No. If they're going to commit the crime, they're going to do it within that 3 to 8 years. I promise you. They will. Clean Slate undermines the concept of personal responsibility and facing consequences for your action. How? You're still serving the jail sentence. You're still doing a probation time. You're still doing your parole time. Again, Karen, how?
I need an answer ASAP.
Police will be so busy sealing records that they won't have time to do their job. It's keeping us safe. Boy, the police ain't...
Woo, that'll do it. You don't have to worry about me. You do not have to worry about me.
Police ain't got nothing to do with the sealing of the record. We already know it's the Office of Administration, the Court Administration, them people doing it. Why would the police officers be the ones sealing the records? This is how you know it's that 5th grade education. Because if y'all had known that there are other branches of government and other people in government and the courts, and you didn't know there's somebody else that could have did it except the police. But in your mind, only police works for criminals. You're ignorant.
I said what I said.
Just ignorant. This means criminals will be given jobs over people with a clean record.
Okay.
Yo! So you think just because you got a clean record, that automatically makes you more intelligent or a more qualified person? Do y'all forget that some of these people that have these crimes are like knuckleheaded young people? It just amazes me that some people with a clean record have just I'm better. Like, what if the old record was just teens drinking? They were caught drinking at underage. They was caught smoking ganja in another state that it wasn't legal in. Some dumb, they were young and they were breaking into an old abandoned building or something like that. They jaywalked. You see what I'm saying? It don't make you more intelligent just because your record is clean. I always personally used to say some of our most intelligent black youth are in the juvenile system right now. Because man, and just skilled, talented, from athletics all the way to brains in the system. But it's just crazy that you think because your slate is clean that you deserve it over anybody else. If they're more qualified for you, had more skill, had more experience, but just had a criminal record, and you had less than all that, but your record is clean, you think that you're mad if they have a fighting chance because you knew you didn't have one when they weren't a criminal. Y'all knew that without some black people having a criminal record, they were going to start surpassing people. Not having that felony or misdemeanor that keeps them down every time he gets checked. Yeah. Be very afraid. Without this law, I can see the record of anyone I want. They said currently, you need a person's full name, including their middle initial, their date of birth, and you got to pay $95 to see my criminal record. So what do you mean? Were y'all out here just dropping $100 to see people's records?
The ghetto!
That law basically said, stop it, Karen. You're just talking at this point. Last one. Roommates and residents in owner-occupied multi-unit housing are at risk. Housing was one of them things that they listed, like I said, you just read the damn law, read the damn act. Was one of them things that was listed that they could check the records. And then some of the major reasons, they can't even get the record sealed. So y'all, that was the last one. That brings us to the end of the video. Don't forget to like this video and give it some thumbs up. Let me know y'all thoughts in the comments. I want to know, one, do you see does it look like a fresh, clean slate to you? Or do you see the little dirty, dry board that I was seeing? And two, is this good enough? Is it a good start? Do you feel like it has a lot of tweaking and developing to do over the years? Let me know your thoughts in the comments. I'll talk to you later.
For me, break, for me, break the body for me.